today we are going to see about the topic is in Indian Contract Act 1872. We are going to discuss about what do you mean by contract and what are the essential points which is needed for a valid contract. First of all, what do you mean by contract? So contract is nothing but it is a contract is equal to agreement plus enforceability. Okay. So then what do you mean by agreement? Agreement is simply it is a promise which is will be done by the one party to another party. Okay. So which is whatever the agreement which is enforceable by law is known as contract. So as per Contract Act 1872, contract is nothing but a contract which is enforceable by law. An agreement which is enforceable by law is known as contract. Here we have given 8 essential points for a valid contract. If a contract means what are the parties should have need to carry some points. First of all, there should be minimum of 2 parties. If a contract means there should be 2 parties, party A and party B, which means one person offering something and other person accept the same. So there should be 2 parties on there. One party is offering a contract, another party is accepting the contract. So there will be a minimum 2 parties. So for any contract which is lawful, we need 2 parties to sign a contract. And next one is legal relationship. So what do you mean by legal relationship? It should be by law relationship. So 2 persons means they should do a legal business. Okay, legal business, whatever which is by law business, there should be a legal business. We have classified many businesses out there. So here legal relationship means that 2 parties have, there should be a minimum of a basic elements should be there. So they have to fulfill the basic elements. They have to fulfill the legal relationship. And then lawful consideration. There should be a lawful consideration. What do you mean by consideration? Say for an example, if 2 parties, party A and party B, party A is going to sell a house to party B means party A is the first party and party B is the second party. So they are selling the house to B means for B the house is the consideration. For A the amount is the consideration. So it should be a lawful consideration. For any contract, consideration should be there. If no consideration means there is no contract. Okay, the same for linked with the legal relationship also. And then competency of parties. So what it means competency, which means the capacity of parties, whether the parties having attained the age of 18 as per Indian rule, whether the parties having the capacity to sign a contract. Okay, so there should be no like lunatic person, off-minded person, or any other kind of off-minded person should be there, should not be there. So if a contract means both the parties should be personally, physically eligible and mentally eligible. That is known as competency of parties. And then free consent. There should be a free consent. Party A should clearly mention about the house which he is going to sell to B. And B is also knows about all the things about the building which he has to buy from A. And what about the money? Okay, when will the amount has been transferred and when will the property has been transferred? So all the information should be known by each other. Okay, party A should inform all the information to without any doubtful, without any default. A should clearly mention about the all type of contracts, all type of elements in the contract, about the building, about the property, about the money, whatever related to the contract. And B should ask whatever the doubts he is having or she is having, should clear about that. So that is known as free consent. If there is no free consent, there is no contract. And then lawful objects. There should be, the object should be lawful. If a lawful object means as per Indian contract, there is a element is there, which product has to sell, which product is not to sell. So that is known as lawful object. So whatever the product that you are selling to other party, there should be lawful object is there. The object should be lawful. And then possibility of performance. Possibility of performance means it should be, the contract should be like all business contracts is not able to perform. Okay, some contracts will be, it will be, we can say the nature of the completion will be not possible. So in some cases, the particular contract will be not performed by the parties. In such cases, if the contract is not performed by the parties means it is impossibility of the performance. Okay, so the contract should be possibly it should be performed. And then legal formality. So legal formality means the signing agreements, whatever done by the A and done by the B. Both should be known about the legal formalities, about the property selling, about the business selling, whatever may be. Okay, so these are all the basic elements which will fulfill to make a contract. Okay, there should be a minimum of two parties. It should be a legal relationship with lawful object and the capacity of the parties. This should be all the things should be clearly which is under the points carried for the valid contract. Okay, thank you.